The expert for today's session is Dr. Mansi. I welcome you, Dr. Mansi, to today's session. Dr.
Thank
Mansi Sharma is Assistant Professor, School of Law, IGNOU. She has done her BA LLB from Lucknow University, LLM from Banaras Hindu University, and her LLD from Lucknow University. She specializes in human rights, human trafficking, environmental law, and criminal law. She is she has a number of publications to her credit, and she's very much involved in our sessions, and she takes up sessions for the students on patent, IPR, and other such topics also. I would now request Dr. Mansi to please take over and start her session.
Thank you, Dr. Sujata. A very warm welcome to all of you. I'm very glad that NCID gives me this opportunity to interact with you all. Okay. So the topic for today's session is that how do you plan to start a startup and what are the legal issues and ethical issues which one has to take into consideration. So whenever you start up thinking of an idea, that idea can be something which has some realistic goals. That idea can be something which you just think about it and then the next moment you think that it will not be workable. So any idea is not a startup, but yes, idea gives you a pitch to initiate a startup. So if you feel that you have a reasonable belief that this is the gray area wherein you need to bring in technology, you can give your inputs and you can do something good for the society, something which is new, something which is novel, something which is not done. It can add to the existing work, it can improve the existing work. Suppose there is a drug and you want to further add on something which is beneficial for other patients also. So we have seen that sometimes it happens that there is a machine. So the machine is improvised. So if you improvise a machine, if you work something which is new or something which is adding on to the existing work, then that will be able to give you some recognition. So idea has to be there initially and then you have to do your review of literature. It is very important that today I have an idea, maybe other people also have the same idea, so I have to understand that whether this work of mine is done by some other person also, or I am new in this field. And if I am new in this field, if others have also done something related to my field, then that will give me an experience, that will give me a exposure of the existing work. So I have to also research. Maybe I will do an empirical research, or maybe I will read the data which is available on the government websites and then move forward. For scientists, it is very important that whenever they come up with a new formula or a new chemical, they always check the international records also, so that they are aware of this fact that this has come as a new invention, or this is something which is adding on to the existing drug. So if you have to understand this, how will you understand what is the way wherein you can find something that this is what I want to present? So I have an idea. Just a second. Yes. So can you all see this?
Yes, ma'am.
Is this visible? Right. Right. So so When I
Yeah,
talk
so
about
sorry for
this,
interrupting. Can you make it in slideshow mode? That will
I
be
have done
better.
it. Sujata, I've done it.
Why is
Is
it
it
showing
visible
two
to you all?
panels? It is showing two panels on the side also.
Just a second. So is it visible now?
Yeah, very much visible.
So when we talk about how will we start the startup, it is very important that we also understand that what are the basics of it. So one thing which is very important, is to understand that the idea has to be novel and achievable. Action. Take it. So, you have to understand that you have to do some market research. Then you have to create a business plan. Is the PPT visible to all of you?
No.
No, ma'am. आपको उसी पे बैकलिंक
Okay. So sorry for the technical glitch. So, you have to do a market research. So, is the PPT visible?
No, not yet.
No, ma'am.
Okay. Just give me a few seconds. क्या इशू हो रहा है? Is it visible now?
यहाँ पे पीटी है।
Yes, ma'am.
ठीक है,
नेक्स्ट करेंगे तो
नहीं आ रहा। इतनी जगह क्या ओपन है?
चेक करो यार।
So now is it visible to you all?
Yes, ma'am. Yes.
Okay, fine. ठीक है. Great, thank you. So, you have to do a market research, then you have to create your business plan. And when you create your business plan, it should be for short term and for long term goals. So, it is very important that you decide your short term and long term goals. Then you also identify your key metrics for the business, so that you can just check or verify that whether the business is moving in the right direction as you have given in your business plan, or you have shifted the business, or the core areas are not touched, or the core areas are different now. So when you have the key metrics, you can always relate to it and you can check it that whether the long term goals and the short term goals which I have made in my business plan are matching with the existing business. Then you also have to decide the terms and conditions. Terms and conditions are very important, because if you do not have your terms and condition as to who can become your partner, as to what will be the share of profit, what are the types of shareholders, what is the percentage which you will be sharing with the other people, how many people you will employ, and what are the terms and conditions which you will focus while employing a person, so that whenever you give them a agreement or a contract, you have clear terms and conditions, so that if they have to take off, what are the conditions, if they want special privileges, what are the conditions, what are their working hours. So we have labor codes, we have labor law, but your terms and conditions have to be as per with the law. So it cannot be that it is contravening any provisions of the law. So existing law cannot be touched upon. You cannot say that my conditions and my terms are against the existing laws, because anything which is against the existing laws is void ab initio. So you have to understand that your terms and conditions have to be legally correct. It cannot be that you are making a term or a condition which is against the law. So do you have any questions on this? When we start thinking about a startup, it has to be new. I have to do my market research, I have to do the business plan, I have to make short term and long term goals, then I have to check that whether the business is moving on the right track, and then I have to also decide the terms and conditions. So what are the contracts, whatever understanding is between the two parties, when we say that these are the roles and responsibilities of the two parties, and you also talk about the risk and define the liability of each party, that is a contract. So it should have an offer which should be accepted by the other person for consideration, and it should be enforceable by law. It can be also written. So when I say that the contract has to be for a consideration, that means that whenever you do not have a consideration, it is not a contract. Secondly, it should be enforceable by law. So I cannot do a contract with you for something which is illegal. So I cannot sell drugs, I cannot sell arms and ammunitions, because I have not been authorized by the government of India. Only those agencies can sell and procure and can buy arms and ammunitions which are authorized by the government of India. So I cannot do something which is not permitted by the law. So I have to take approval by the law. So what is your legal structure? Your structure of your business can be unregistered, and your structure can also be registered. When I talk about registered structure and when I talk about unregistered structure, what all is included in unregistered structure and what all is included in registered structure is very important. So, the sole proprietor can be a part of unregistered structure. Then, unregistered partnership is also a part of unregistered structure. And if the partnership firm is registered, then it will not come under the purview of unregistered structure. What are the benefits of unregistered structure? Your data is not available with the government because you are not filing it anywhere. You are not sharing your data with the government or any other agency or any other government body. So your data is with you. It is not shared with the public, and the valuation and logbooks are with the owners and not available for public scrutiny. You can make internal changes without any approvals or permissions because you do not have a registered structure. Your trade secret is maintained because you, as a owner, know your trade secret and you do not share it with the government or any other agency or with other people. And the commoner is also not aware about your trade secret. Your costing is also less. Your risk is less in terms of losing important data, and you can avoid leakages. When I share my data on the government platform or with the statutory approvals, then from there the data can also leak. But if I do not share my data, then the data will not be able to be compromised. So my data will not be compromised. And I have a single hand control. So I can make my terms and conditions, I can make an offer, I can decide my business as per my decisions. A registered structure includes a limited liability partnership and a company which can be private or public. Generally, we do not have public companies, we have private companies, but the registered structure includes limited liability partnership, which we call LLP, and a company which can be private or a public company. So the benefit of the register structure is that the documents are available with the government. The annual report and statutory approvals are also there with the government. Liability is shared between the partners. So you are not the sole person who will be deciding everything. There are some other people who will take decisions for the company or for the firm, and they will also share the liability. Then, as a commoner, I can check the credentials and the balance sheet. I can also share the records which are available on the government websites or which have come for statutory approvals, even on the website of that company or a partnership firm. I can check all these details. And in case of death or dispute or disability of one person, the company survives. So, it is not that this is one single point person contact. So, if something happens to me, the company or my entire business will come to an end. If I have a company or if I have a partnership firm, then my company or my partnership firm will further continue even if I'm no more there, or I have a dispute with my partner, still the company and the partnership firm will continue till the winding up procedure is not there. So my company does not end with my death or in case of dispute or in case of disability. So the workers' interest, the employers who have employed them, even if they have a dispute, the business still remains. So the interest of the investors and the interest of the workers is protected. What are the advantages of sole proprietorship? When I start the business, I'm the single person running a business. So what are the advantages? One is that ownership is with one person. It is single-handed owned and controlled. Owners receive all the profits benefit and will bear all the losses liabilities. and it is easy to set up and maintain. What are the disadvantages? Owner and business is referred to as one entity. So as I just said, that if something happens to me, the entire business will be affected. Unlimited liability of the owner is there, so it is not a limited liability company wherein my liability is as per my share, but I am responsible for the entire business. So if the business is at loss, it is my loss. If the business is at profit, it is my profit. And I cannot add on to any person because this is a sole running business. I am the owner of this business. I cannot add any other person. Otherwise, the form of this business will change. What is the process if I want to run my own business? What is the process? I have to decide my trade name and I have to take registration. Then I have to open my bank account and pay GST and other taxes. Do you have any questions related to the sole proprietorship? If you have any question related to the sole proprietorship, then you can ask me. Otherwise, we can move forward. So if I have my trade name, I register and I open my bank account and pay GST and other taxes, then I can open my business. Then what are the advantages of the partnership firm? I just said that two or more people, come together and open a partnership firm. So they share the cost and responsibilities. Terms and conditions are fixed. If I want to take this benefit, I will decide that, okay, this is my share, this is my responsibility. It is there in the terms and condition which we have signed as a contract. Then, if I want to only give some financial assistance to the company or the firm, then I can become a silent partner or a sleeping partner, and the other partner can take all decisions on my behalf. So I can decide that I will only look after the finances of the business and I want to only invest my money. So I can become a silent partner or a sleeping partner, and the other partner or partners can take my business forward. It is also easy to set up. The disadvantage of this kind of a partnership firm is that in the sole proprietorship, what I was doing is that whatever decisions I was taking, it was coming to me. So if I take a good decision, I will get benefits. If I do not take a good decisions, I will suffer the losses. But if I have two or three or maybe 200 partners or 300 partners, I will be liable for the other actions. So this is unlimited liability is there, and the benefit of slab rate taxation is not applicable. Otherwise, as a sole proprietor, if I earn this much of amount, maybe this is only coming in 10% of taxation. If I earn more, then it will be coming in 20% taxation slab or 30% taxation slab. So the benefit of the slab rate taxation is not applicable in terms of partnership firm. And what is the process to register? You have to draft a partnership deed, then you have to execute it on the stamp paper, apply for PAN card, and open a bank account in the name of partnership firm and register it or keep it unregistered. I already told you that this partnership firm can be registered or can be unregistered. If it is unregistered, then you do not have these legal complications. But if you register your partnership firm, it also has some advantages because your terms and conditions are there. You cannot, a person cannot take his own sweet will that, okay, this is what was agreed, but now I do not want to follow it. So when you register something, it is legally binding on you. In case it is unregistered, then you will file a case where, the provisions of the contract have not been adhered to. Then we have limited liability partnership, where two or more individuals share cost and responsibility. Terms are recorded, and in partnership agreement, the terms and conditions are there, And you have to register this limited liability partnership, which we call LLP, with the Ministry of Corporate Affairs, and you have perpetual succession. So, your company or your firm continues and other people will join in. What are the disadvantages? One is that the slab rate taxation is not applicable in this. You have more legal compliances because in cases of a single partnership firm you have less of a laws to adhere to, but in case of LLP you have to adhere to more legal uh, uh, provisions. Then you have to regularly maintain your registers with MCA, and you have to also file your details or your returns or your profits. Your balance sheet has to be there with the MCA, and the MCA will also audit. So every year you will present your balance sheet, your other details with the MCA, and they will check it and they will audit you. What is the process to start this limited liability partnership? You can reserve the name of LLP with MCA, and before reserving the name with LLP, you have to check whether this name is unique or different, or the name already exists. Suppose I have a trade name and you start up on a very similar name, so that will not be reserved. So the MCA will check it and will not grant you that name. So you have to do a fact finding or to check up that whether the similar names are there or not. So if the similar names are there, then you cannot have those names. So your name has to be different than the existing companies. Then you have to apply for digital signatures of partners. You have to draft a partnership deed and get it executed. Then you have to file document with MCA and wait for registration certificate, apply for a PAN card, and open a bank account in the name of partnership firm. What are the advantages of a private limited company? This is a separate legal entity. You rule by your charter documents. Ownership is broken into small shares. Board of directors run the corporation. Shareholders have limited liability and are not responsible for the debts. So it is very important, I am only responsible for my share. I am not responsible if the company suffers loss. So you get your profits as dividends, and each share has one vote. So for all the important decisions, I will vote as a shareholder. So this is more democratic. So in case of sole proprietor, you will work as you want to work. In case of partnership, two or more people will work as per their expertise. But in this, once I have my voting rights, I will also take or be a part of decision maker. So I will feel that I am a part of that company. I give my vote and I also take decisions where the company has to go forward. A disadvantage is double taxation on net profit if distributed on dividends. So you have to pay double taxation. You cannot give loan to unrelated people. It is very important, whatever benefits are there. So the clause is that you will be these if this is your benefit or this is your profit, this is the way you will work on your profit. So it is not that I can go and give loan to any cause or any unrelated person. I have to give loan or I have to give money in the cause which is mentioned in my memorandum. So you have to annually file the your annual statement with MCA, get it audited, and winding up is also difficult. So, the process is clearly mentioned in the memorandum of understanding and other documents. So once you start your company, you can start it, but you cannot end it in one day. So today I have a company and I do not want to continue running that company. So it is not that I will just say that, okay, I just wind up this company. Winding up also has a legal procedure. So the interest of the shareholders, the interest of the workers who are working in that company is protected, and I cannot take my own decisions of starting a company or ending the company or winding up the company. The government will take its course and it will decide, keeping in view the benefit of the workers and the shareholders. How will you incorporate the company? You have to check the trademark, then reserve the name of the company with the MCA, apply for digital signatures of all stakeholders, file application with MCA, and then the MCA will issue a certificate of incorporation. PAN and TAN will be allotted to you. You open your bank account and file business commencement certificate with MCA. So, once you get this business commencement certificate, then you are ready to start the business. How will I decide that whether I should start a partnership firm or a company? I will look into the tax benefits. If I start a partnership firm, then what are my tax benefits? If I start a company, what is my tax benefit? Then what will be my team structure? So if there are limited number of people in my firm, then I will start a partnership firm. If I want more and more people in my company, then I will start a company. So liabilities will also be decided. In a limited liability partnership, the liabilities are limited. In a partnership firm also, when I have my terms and condition, the responsibilities are there, then I will be liable for my portion. Then future prospects, if it is a overgrown business, it will grow every year, then maybe I will have more people to join every year, so I will start a company. If it has a limited workforce or a limited area of operation, then I will go for a partnership firm. Then sometimes, it also happens that I also want my firm to have operations in other part of the country or in other countries. So then I will apply and check the FEMA rules and regulations, and also have an office in other parts of the countries or outside country. So the residential status will also decide that whether I want to open a partnership firm or a company. Why to incorporate is very important. That why will you like to incorporate? Because I want to start my own brand, or I want to have my own business, and I want to maintain my profit and loss account separate from my own account, from my own individual account. Then I want more members in my team, because maybe I'm good in calculations, or maybe I'm good in drafting, but somebody is there who will look after the technical side, somebody who will look after the sales team member, somebody will pitch in more ideas. So I need more members in my team, so I would like to incorporate it. Then I want to issue shares and to add co-founders. If I am a legal entity, then only investors will like to invest in me, in my business. Otherwise, if I come up with an idea and I just meet you and tell you that, okay, today I have an idea and I'm starting my business, then will you like to invest in my business? So if you know me personally, then also you will think twice that, okay, you are giving money as a individual or you are giving money as a legal entity. So revenue generation and expectation also changes, because if I invest in a business, I want profit. If I do it for a social cause, or if I do it with love and affection for family members, then I do not expect. and how to exit. The exit rules are there, so you will know that okay, if I want to end up this business, then today I have started my business, now I want to end my business, so what are the rules and procedures which need to be followed to end the business. You will identify your brand name and your legal entity. Then you will check trademark for brand name and legal name. As I just said that the existing brands cannot be your brand name. The existing trademark or the logo or design or the ringtone or the music cannot be the same for your brand. Roles and responsibility of the founding team members, along with their profit and loss percentage, will also be there. And then you will be selecting the right entity as per your business need. So, this is also important that I will decide that I will work as a sole proprietor, I will work as a partnership firm, I will work as a limited liability partnership, or I will be working as a company, a limited company, or a public company. Then it is very important that when I talk about branding, when I talk about registration, I should know that okay, what is patent. So if I have invented something, then the patent office will provide me exclusive rights for my invention. So if I have invented something that is new and then I register myself as a patent and I get that patent registered, then I will be using it exclusively for a period of 20 years and I will be getting some benefits out of my patent. Trademark is a sign that distinguishes the goods or services of one enterprise from the other. So I just told you that you have a trademark. Every company has a trademark. So if I want to open a company in the name of Google's, I will not be able to open it. If Uber is there and I want to open a company in the name of UberX, or Coca-Cola is there and I want to have a brand or a product called Coca Z, then I cannot have it. Easy is there, so I cannot have a product called Ezex. So a trademark is there, so you have to respect that trademark and your brand should not be the same. So it distinguishes the goods or services from the other. So we have lot of duplicacy, a lot of duplicate market going on. So we find that Gucci is there, and for similar item, we also find that Gucci X is there, or maybe there is a difference of a word or a letter in that. So you are able to think that this is the same brand which I have been looking for. No. If I buy a easy bottle or a milk powder and I feel that this is this brand, and somebody is using the color or the design that is illegal and that person cannot use it, because I will believe that this color is associated or this design is associated with this brand, so this belongs to that brand only. Then, copyright is a legal right granted to a creator for his literary or artistic work. I am a very good painter, so I will get my patent, my the painting copyright, so that or this PPT as a copyright material, because I do not want anybody to use without my permission. So I can get my artistic work registered as a copyright or my literary work as a copyright. Then geographical indication is also very important. You must have heard about different varieties of mangoes. So if I talk about Alfonso, you will relate it with a particular geographical area. If I talk about the sherry arm, or a langram, you will like to relate it to a particular area. So, a sign used on goods that have a specific geographical origin and process characteristics that are essentially attributable to that place of origin. So, when I talk about basmati rice, I know that this basmati rice is grown in these areas. Similarly, I know that this is the origin of chicken work. I know that this is the origin of Meena curry. So I can relate it with that geography. I can relate it or Banarsi silk when I know, or tussar when I know, then I can relate it to the place where it is. So when I talk about geographical indication, it has to be from a particular origin. It has to have some special characteristic which is limited to that area. When I talk about industrial design, it constitutes the ornamental or aesthetic aspect of an article. So, I have a design. So that design differentiate my article with the other person's or the other brand. So I have an industrial design which has to be there, which is recognized and registered, and then no other person can use that design in his or her product. What is the need to safeguard my IP? It is very important. I want to earn from my licensing. Suppose I have got something patented, then I cannot manufacture it because I do not have that technical know-how. I am a scientist, so I cannot start a bulk manufacture of something. But I will give my license to the other person, and that person will give me certain amount of benefit, so that for a limited period of time he is able to use my license. So I want to have some technological development, and I also want to block the existing competition. So if I tell you that I have come up with this idea and I have developed this, then you will not be reinventing the entire thing again. So you will develop further, and what is my area of expertise, you will also not think that okay, you will be also doing the same thing. So it blocks the competition, and it also talks about the development. So whatever development will happen from the next stage. So whatever I have developed will be my, and whoever is going to develop further will add on something to my existing development with my permission, and I also block the competition. Then I earn rewards and recognitions because it's very important. A lot of scientists have given their entire life for making new inventions. So, coming up with a new formula or a new invention is very difficult. So, you have invested your entire life. So, you also need recognition from the general public, from the government, and you also get award. To build a brand is also very important. I have a brand value, so my reputation is based on my brand value. And then also I want to raise funds. So if people know me that I'm a successful businessman, or they know my company, my legal entity is there, then I will be able to raise funds. So whatever these mutual funds are doing, or the share market is doing, is they have brands and they are raising funds on their brand value. Then it is very important that I also talk about my IP valuation, because till I talk about my intellectual property valuation, I will not be able to understand that how to safeguard my finances and how to raise funds. So I know that this is my existing valuation. I want to raise funds to increase my value. So We have to make some management decisions so that my existing value of my business increases in a later point of time. Then, to access the damage claims in business, dissolution, infringement, and breach of contract, I also need a valuation. So, how will I file a case for infringement if I do not know what is my IP valuation? So, even in case of dissolution, I should know that this is the company asset. This is my profit, this is my loss. Then only I will be talking about dissolution. These are the people who are working under me, and this is what I have to pay to them in case of dissolution. So, if I want to end my business, I should know that this is my liability. Till I know my liability, I do not have my IP evaluation, then I will not be able to dissolve the company.
And
In
Dr.
case of,
Mansi, sorry,
yes,
I'm disturbing, interrupting. There are a few questions. Means a hand is raised, so
okay,
you
okay,
will
okay.
be taking the questions later on, or you want to take it in between?
Nay, they can ask.
Okay. So
Okay.
there is one query in the chat box by Pravalika. She is asking if sole proprietorship and one person company is same. So she asked
Yes,
that.
yes, 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 yes. Definitely, sole proprietor means that a single person is earning the business, or is a single person is running a business. So, sole proprietor and a single person running the business is same, because I just told you that one person takes the entire decision. One person is there to take all the decisions and the responsibilities in that. A business, he will work as per his expertise and his capabilities, and will either, give profits to the company, to the business, or will suffer losses. So he will take his own decisions in case of his death, or when, in case of incapacity, the business comes to an end. So yes, another question.
Then Tapanjit has raised his hand. So
Yes.
Tapanjit, you can ask your question, please.
Ma'am, if you registered a company in MSME registration, so it considered as a sole proprietorship or anything else?
No, when you register it as a company, it is a private company. Okay.
Because there is an option, ma'am, that we can register in MSME registration.
Yes. So when you register it in SME, you either register it as a sole proprietor, because you are the only person who will be taking care of the business, or you register it as a company wherein you say that these are the people who are in my company and I want to register it. So if you are registering it as a group, it can be a partnership firm, it can be a company, but when you are registering individually, then only it is a sole proprietorship.
Yeah, okay, ma'am. Ma'am, second thing I just wanted to know, can you please explain a little bit about trade secret too in IP?
Okay. Trade secret is very important. I will discuss. I'm just coming to the trade secret. It is very important. When I said that you are a sole proprietor, so, whatever trade secrets you have, a chef, a lot of people, have started the business on streets, and they are making different items, coming on the street and selling that off, and they have separate masalas or some recipes which they do not even share with the YouTubers. So whenever you interview them, they will say that this is my recipe. So that recipe is their trade secret. They do not want to share that trade secret with the commoner, because, maybe they do not want to have more competition. So if I also share my ingredients of that recipe, maybe you are able to come up with a better taste, so I will lose on business. So I will be just coming, trade secret I will discuss in maybe 2 3 minutes. Trade secret is something which is limited or restricted to my trade. So, as a person, I will decide that this is my additional benefit, which is different from the other company. How will I differentiate my substance or my product with the other product? This is my trade secret. Two products cannot be same. The same chef will be making a different thing one day, and will have a different taste the other day. So the masala or the variety which he is changing, maybe he puts more of the other masala one day and less of the other masala the other day, but you will never be able to know what all has been put in that masala. Think of Coca Cola. They have never shared the components of their Coca Cola. So that is their trade secrets, which is very important that every company has a trade secret and they do not share it with even the shareholders. So they have a limited number of people who will be knowing about that trade secret, and they will take into confidence only those people who are related to them. So it is not that you as a shareholder will ask them that this is the trade secret you want to share with me, and they will share or they will provide you an RTI. So if I want to file a RTI for a company and I cannot ask them that what is your trade secret, no, they will not disclose it. Even in the memorandum of association, when they make the company, then also they will not give the details of their trade secret. So trade secret is something which is very essential for differentiating that trade with the other trade. And trade secret is very important to understand, because if you tell everything and anything and everything about your company, then maybe your company will have more what competition, because you want to have some leverage and you do not want to share your trade secrets so that your company has a edge over the other existing companies. So I have made a formula. Coca-Cola is there as a formula. I do not share with other people so that the same taste is not there in the other substance. KFC has a masala. So what differentiate KFC with the other brand is their masala. So that is their trade secret. Lot of companies have come up with bio product, green products. So that is their trade secrets. They will not share it with the other people because they are not liable to share their trade secret with the other people. And if I, as a member of that company, infringes their trust and shares the other document, the legal document with other people, or share that formula with the other person, then I can be charged for breaching the contract. So it is very important that whatever makes you different from the other company is your trade secret, and you do not share your trade secret with anybody and everyone in the business, because that makes you different from the other. So you understand, I want to make a company and I know a particular recipe. I want to further, make some changes in that recipe and try. So whatever tried and tested method I have used and I have come up with a formula, I will not share it with the other person, because that person will be able to get my thing and will also start manufacturing the same product. So how will it be different? Maybe he will be coming up with a better option or a better variation. So my trade secret is something which is restricted to my trade, which is my individual or a group effort, and I should not be sharing it with the other people. Any other question? Any other question? Sujata, can you hear me if there is any
Yeah, yeah. There is Ayush Pathak asking, is the trade secret only applicable for food industry?
No, no, no. Even for the technical equipments, for technology, for these all the scientists are having their trade secrets. So whenever we talk about a particular group of scientists, they have their trade secrets and they do not share it with the other people. Even the government of India has a trade secret, because the arms and ammunitions have been developed by a trade secret. So the government of India will not share those details with the other people. The army will not share the details with the other people, because we have developed a particular bomb or a particular arm or a particular formula has been developed by these scientists working in the labs. So that is also a trade secret. I will not give you my formula in terms of technology. It can be for mobile phone. Apple never shares the trade secret. The Samsung, Nokia was a leading brand. So people say that Nokia was not able to compete with the change in the market scenario. So somehow, the other companies came up. So trade secret is there for the scientific equipments. Trade secret is there for the agriculture, equipments. Trade secret is also there for the garments, for the manufacturing business. Trade secret is there for food and agriculture. Trade secret is also there, for game designing. When we talk about the computer, the technological part, so this trade secret is there because no company, the Samsung will not share the details of its trade with the other company, because what difference is there when you are talking in, even in case of cosmetics, they have a trade secret. A lot of organic brands are coming, but they will also not share their trade secret. They will only give you the ingredients. They will not tell you that this is how they made the product. They will not give you a demo, or they will not be training you that okay, this is how we develop this formula or this idea. Even the vaccines which are coming up has a trade secret, because the formula, the kind of composition they have, that is a trade secret. Otherwise, why one company is earning so much making vaccines and the other companies are not able to come up with that vaccine? So every company has a trade secret.
Hello, ma'am.
Yes.
Ma'am, I have several questions related to it. Like
Okay.
for copyright, we have a legal method. So if I wanted to save my trade secret, so there is a legal method for it. First question. Second, how can we know that it already exists? Sometimes we develop some type of ingredient. Like if I'm talking about myself, I just wanted to start a ice cream company. I have my unique recipe, but I just wanted to know it already exists or not. Third question, it may be happen that if anybody is using that method, so how can you relate and how can we consider that whose state secret we will give, that who come first or something else, ma'am? I have three questions.
Normally, the trade secret is a part of your patent or your copyright. You do not register your trade secret. Why you do not register your trade secret is because that then this is not a secret. If I give all my details to the the government or to the this MCA, then this does not remains my trade secret. So I will never share my formula with them. I will only tell you the procedure, the steps involved. So I will not give you a demo. I can give you the details that this is a part of my uh, manufacturing, or maybe when I come up with this idea, this is how I develop my idea, and the product is the result of this idea. But I will be not sharing you the details or the intricacies that yes, this is how I made this product. So I will be only telling you the steps. So trade secret is not registered in India. We do not have trade secret registered in India. There are a part, it can be a part of a patent, it can be a part of a trademark, it can be a part of, a copyright, but, or it can be a part of your geographical indication. But we do not register our trade secrets, because whenever we talk about registering, that has to have an entire process, a detailed process. So anything which is secret will only remain secret if it is limited to a particular group of people or is with that person. So whenever you have a recipe, whenever you have some technological intervention, you do not share it. That trade secret is limited to a group of people. You don't even want to share it because we don't want to need, you know, I can tell you that the way I take this class or the way I will take another class on the same topic will be different. So I will never, you want to come up with a business of ice cream. So the ingredients may be the same, but the proportion which you are using is different. So you will never share that proportion with the other person because you know that you want to avoid any kind of competition. Or if that person comes up with a better proposition, or he's trained, he's experienced, and you tell him that this is my trade secret, and I will come up with a better idea or a better product. So it can be in terms of emanations, it can be in terms of technological intervention, it can be in terms of a laptop or a mobile, or a design. I will also now share the details of how I print a particular product. So what are the intricacies means I will not share it with you. The process will never be shared with anybody else, and that is my trade secret. So you why will you want that other person should know that what is your trade secret? The way you are making a ice cream has to be different from McDonald's or from the other brands. So if that is a quality wall ice cream has to be different from ice cream from Mother Dairy or from Amul. So why will they share the trade secret? They will not share because they are competitors running parallel businesses. Similarly, if you want to come up with a new ice cream formula, you will not share your formula. So it is never registered. In some European countries, they do register the trade secrets related to army, related to the nuclear technology. But that is also limited to a few people or few government officers who are accessible to that information. Otherwise, in India, we do not have this. That can be a part of my patent, but I will not be sharing you the details of the entire process which I have gone through. Otherwise, you will come up with a better idea or a better product the other day. Any more
Yeah, okay.
questions?
Ma'am, so if anybody shared my recipe with another company, so I don't have legal method to protect it. Like sometime it happen na, that we have hired an employee, and we tell there is a document that non-disclosure agreement. But sometime, ma'am, we wanted to save our trade secret and recipe. It may be happen that different companies using the same method and same technique. So, like a patent, we can stop and give them a legal notice or anything else.
Yes. Now you have come up with a good question. I have not protected my trade secret, but I have protected the product. So that product is patented. So I will file a case of breach of trust, and I will go for the legal procedure because I will be able to tell that this person was working in my company and now he has shifted to another company and has shared my trade secrets. Lot of media houses, they hire people from surrounding, and then they try to get the information from the existing businesses. So people hire you at a better package because they want the information to be shared. So that is protected under patent, that is protected under trademark, but that is not protected as a trade secret. So I will file a case where my patent is in question. I will talk about that. These are the exclusive rights. When I get the patent, I get some exclusive rights. So I will be talking about that this right has been violated by this person, and I will be filing a suit for violation of or a breach of contract. So there I will take a recourse because my patent is registered with the patent office. So they will check that whether this is a violation of the existing law or not. And if there is a violation in the terms and contract, somebody has breached it, then the law will take a course. Even for criminal proceeding, they can go. So even as a civil suit, I can file a case, and even as a criminal, because when you breach, a trust, it can also have a criminal liability. So in my terms and condition, I clearly mentioned that these are my terms and conditions. If this has been, this is why we say now, a lot of people, whenever I talk about your IP evaluation, whenever I talk about starting a new business, it is very important that you finalize your terms and condition. A lot of people come up with a good business proposal. They also start the business, but after 1 or 3 years, they close it because they are not properly planned. So whenever you make a business proposal, you get it approved by or you get it vetted by a legal person so that he understands the clauses also. I cannot make a clause which is illegal. I cannot give a clause which is against the law, but I have to protect my business. So always hire a person at an initial stage so that you have your elaborate terms and conditions, and those terms and conditions will always protect your patent, will protect your trademark, will protect your design, will also protect your business from being compromised. So invest at the initial stage so that you are at peace when your business grows. If you do not invest at the initial stage and then when the business grows, there are a lot of tensions or internal disturbance between the partners as to who will share what. So, what will be the percentage of your profit? What will be the percentage of your liability? What will be the percentage of your loss? This has to be taken into consideration at the initial stages. You cannot say that first we will come together and let the business grow and then we will decide the terms and conditions. So, as a very good company who started 3 years back is not in existence now, and they came to me for some kind of counseling. The two partners have broken, and they came for legal advice. And then when I saw their contract, I saw that the other person was only talking about his rights and liabilities, and the second person never even talked about his rights and liabilities in the contract. So at the first stage when you are making your contract, you do not talk about your rights and liabilities. How will you protect your rights and liabilities? So whenever you have a employer and employee contract, you have to clearly mention your terms and condition. So, in case of violation of the terms and condition, in case of a breach, or in case where the other person has deceived you or maybe cheated on you, you should have clear provisions so that you can get the benefit of law. Otherwise, if you do not have these clauses in your contract or in your terms and conditions, do's and don'ts, are very important for a business to bring. So if you do not have these do's and don'ts, and then you start your business and later on you suffer, in when it goes for liquidation or when it goes for winding up, then you have no option than to compromise, because your rights and liabilities are mentioned but the other person's rights and liabilities are not mentioned properly. So drafting is very important. So initially whenever you start a business, you cannot be good in all things. So I just told you that somebody will look at your technology part, somebody will design a website for you, somebody will take care of the legal issues. So whenever you draft your terms and conditions, whenever you go for a patent filing, why we suggest that whenever you go for a patent filing, go through a patent attorney. You can also file it online, but you do not know the law. So you are good in technology, you are good in innovation, you are good at your idea implementation, you are a good businessman, but you do not know the law. So you do not try to do everything. So that has to be taken into consideration. So, you have to assess the damage claims in business. And when I talk about assessing, it is very important. I told you now this is a very good example of a leading business where, in 1 year, they started with a good turnover. And after 3 years, the business comes to an end because there were issues related to who will get more profit, who has given more time and energy in making up the business. So a lot of people invest their money, but they do not give time and energy in running up the business. So what are your roles and responsibility, what are the other person's roles and responsibilities have to be there. So when I talk about these moral issues, we are talking about that legal and ethical issues. So it is against ethics that whenever you change your company, you should not share the trade secrets of the other company with the new company. Otherwise, they will also know that you are not loyal to the company. So loyalty cannot be trained, in 1 or 2 days. Loyalty has to come from within. So if you love your work, if you really respect your work, then you will not be able to share your trade secrets with the other company. Lot of people do not want to shift the companies just for a increase in salary or increase in perks, because they are loyal to their company. And when you want to change, or you have to shift over, I have seen lot of people who just shift in every 3 years they shift. And end of the day, because the your peer group knows you well, whoever company you are working with, when you shift in one company, go to the other company, then you again shift to the third company, fourth company, fifth company, the workforce is same, so everybody in the industry will know you. So you have to also build your reputation, your respect has to be earned. So we always say that some people do not get a lot of salary, but still they are respected in their company. They have that trust factor. So these are some ethical issues. So you should not share your trade secrets. And if you share your trade secret, the other person, the previous company should have certain laws and conditions wherein you are able to catch hold of that person and you are able to get justice for your business because you have worked and given all your effort in running up that business. So,
Thank you so much, ma'am.
okay, so then we have valuation methods. It is very important to understand how the company is formed as per the company.
Mansi, we have 10 minutes.
Okay, I'm just going to end in few minutes, just maybe 3-4 minutes. Okay. The valuation methods are also there. I told you that you have to value your assets. So till you have the valuation of your assets, you will not be able to decide that this is the percentage of my shareholders, this is the percentage of dividends, or this is the percentage of profits which I will be sharing. Even in case of liquidation, in case of winding up, it is very important to have a valuation. One is quantitative analysis and the other is qualitative analysis. If you decide your monetary value or the worth of your patent technology, that comes under the quantitative analysis. And when we talk about qualitative, then the set of patents you have come up, then the factors which have direct impact, it can be the citations, the broadness of claims. So all your claims will come under the qualitative analysis. Then we have compliances. When I talk about a partnership firm, it will have a different kind of set of rules and regulations to follow. It is very important, when I talk about a limited liability company, what is my strength of company is very important, because that will decide whether I will have a pan, I will have a tan, I will pay the service tax, I will have a IEE code, I will be giving VAT, or I will be paying gratuity, PF, ESI. Then I will have board or general meetings, or I will maintain some registers, I will do filing. So if I have a sole business or a proprietor of a business, a single running business, then I don't have to give all these PF, gratuity, ESI, and I will not have these general meetings. I will not get, the labor codes compliances. I will talk about the labor laws. We will also get environmental clearances and licenses. And this is very important that you register these licenses and clearances. It is for a limited period of time that you get all these approvals. Within the time frame, you have to again renew your license. So it is very important that whenever you start a business, whenever you start a company, or limited liability partnership or a partnership, you have to follow the law and you have to renew your licenses on time. Because if anybody comes for a check, or the government comes up for a check, you cannot say that my license is expired, but yes, I had my license initially. So then you will be penalized. So, in the end, I would just like to tell you all that it is very important that whenever we talk about these legal issues, one has to understand that legal issues are very relevant, because sometimes we make a company but we do not know how to go about it, and whether to start a partnership, whether to start as a sole proprietor, whether to go for a limited liability company, or whether to go for a company. Yes, Shushma, you have a question.
Uh, Dr. Sushma, you have raised a hand. You can ask. I was waiting for you to complete and finish. So
Okay, thank you,
there's one more
Sujata.
question. Have you completed? Then we have
Yes, yes, I have completed.
Okay, okay. So, Dr. Shushma, you can put across your question, please.
Good afternoon, ma'am.
Good
Uh,
afternoon.
Ma'am, it was a very nice lecture. I just wanted to inquire what will be better. We should go for an LLP or a private limited company.
Yes,
Which is more better for a small scale industry or small type of startup?
yes. Whenever you have a small startup, you should always go for a limited liability company, because your liability is also limited, and then you have to have less numbers of legal procedures to follow. When we talk about a private company, a company is taken into consideration when you have a particular asset with you. So you cannot start a company with a minimum asset, or a minimum amount of monetary help, or with limited number of people. Once you have a company, you talk about in a broader concept. Whenever I talk about a company, I tell you that you should always have a big support. It should not be only from your family members. If you have only your family members supporting you in your business, then either go for a limited liability company or a partnership firm, because then the binding of procedure is also easy. The laws which you have to follow, the compliances which you have to do is also easy. But in case of company is a company, so whenever you register yourself as a company, you have to follow a lot of laws. Company laws are there, then other contract laws are there, and there you have to maintain a lot of records. And the data is available with MCO also, and is also available on the website. So you have to give some disclosures. Voluntary disclosures are there, which are very important, that it should be there on your website. So web designing, then what details have to be there on the website, what details should not be there on the website, you as a commoner will not know, or you as a incubator, or you as a starter will not know. So I would request that first you start up with a limited liability company or from a sole proprietor, see how your business grows up, and then you can always form a company. So once you start as a sole proprietor, you have a limited resources, but everything is under your hand. So I start as a partnership firm or a sole proprietor. I can plan it, and then I will expand my business, and then maybe I will register it as a company in future years.
So, ma'am, if I am having only a firm or a sole proprietorship, then can I apply for startup funds and all?
Yes, 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 you can apply. Even the small groups have there are a lot of government plans which I just
Hmm.
requested Dr. Sujata.
Hmm.
There are a lot of government plans starting from SMEs, starting from sole proprietors. They have a lot of plans for individuals also. So there are a lot of government schemes which we will be discussing in some sessions. What are the government schemes which are available for a one person? What are the government schemes which are available for a SME? What are the government schemes which are available for a limited liability partnership? And what are the government schemes which are available for a company? And what are the kinds of financial and technical helps which are
So,
available?
so we
How to, yes.
we can register our website domain all along with our proprietorship
Yes,
and can get a startup grant for that because
yes,
like afraid of doing all these things because we are not aware of company laws and the legal procedures will be there and who manipulates you in what way we never understand that. So being an
yes,
academician we can go for only the idea and work and behind that all legal procedures we are a bit afraid of that. So better to start with a small venture so we can go with a firm or not. That was my dilemma or that was my question
yes.
that I'm not clear
You,
about that.
you start with a small venture, but whenever you start with a small venture, you hire somebody from the technical side to draft your do's and don'ts, to
Okay.
draft your memorandum, to draft
Hmm.
your, terms and conditions, because whoever is coming to you for
Hmm.
business will have
Hmm.
certain rights as a customer
Hmm.
or as an end user. So what are that person's roles and responsibilities, and what is your role and responsibility?
Hmm.
So every clause will be taken care if you have a legal expert, because we cannot be good in every subject.
Yes.
So my area is legal, your
Hmm.
area is technology or invention. So
Hmm.
you focus on your invention and give a person some time to understand your business and to draft rules and regulations or conditions or contract provisions as your business, because you will be hiring people or you will be getting services from other people.
Hmm.
So, what are the terms and conditions when you hire a person? What are your service rules? That should be
Hmm.
also there in your agreement. So, what all should be there in your offer letter? What all should be there in your agreement has to be drafted by a legal expertise, because you will get a lot of formats on Google, but the
Hmm.
Google formats are not updated. So maybe we are talking about labor codes now, and you are talking about a provision of labor law. So
Hmm.
that is your miss. You will miss the labor codes because you do not
Yes.
know the labor codes
Labor
and their
code.
implications. But a legal
Hmm.
person who is in drafting only will be able to understand your business well, and will be. I told you now, a very good. One person is of 17 years and the other person is of 25 years. Both of them started business 3 years before, and they came up with a very good asset in 3 years. But there were some mutual differences and they shut up the business, and now they are struggling, to get profits. And the workers who are working in that company are really struggling because they are not being paid their salaries, because there are no laws. They have just given a very sketchy agreement to agreements. So whenever they come up before the law will always take into consideration the legal documents which your company has or your partnership firm has. So if you do not have well law papers, you will not be protected.
Hmm.
Dr.
So, ma'am,
Mansi, we have, thank you, Dr. Mansi. We have two more queries. So, since the time is short, I will just read them out to you.
Okay.
Ayush Pathak has raised a question. He says, as a beginner, how to take the major task? What role shall we undertake and what all shall be distributed to others at the same time, maintaining all this simultaneously? He's saying, and then he has raised one more query. He says, I intend to start a student centric
Centric counseling.
counseling and guidance forum, which would be best sole proprietorship or partnership, because I may be needing other people for development of the forum. I think part of the question might have been answered by the response that Dr. Mansi gave.
Yes.
Dr. Mansi, would you like to add something?
Yes, as you said that you want to have a counseling kind of a business. So I would just request you that start up with a partnership, because when you have your partnership, you have more people as partners, and they will be giving you, suppose you are busy at a particular day and time, they will be able to contribute technically also when they will have sessions. So look for experts in your field, look for like-minded people in your field, and then you start up with a partnership firm and decide your roles and responsibilities and your asset sharing mechanism in the initial stage, so that you do not suffer later on. And even the some people are sleeping partners. So for a sleeping partner, if I am a sleeping partner, my roles and responsibilities are different. But if I'm an active partner, my roles, responsibilities, and my share in the business will be totally different. So that has to be understood.
Thank you, Dr. Mansi. There is one more query. Arun Kumar is asking, what is major difference between private, public, and LLP company?
Okay, the limited liability company partnership has a limited role, has a limited liability. My liability is only limited up to my share, whereas the company, everybody, the shareholders will have limited liability as per their share in the company. But the winding up procedure will be totally different in case of a company. When I want to talk about a public company, normally a public company, nobody goes for a public company in case of business, because public company is something which has some public rights and public involvement. So nobody wants to go for a public company. In cases when we talk about business industry, we do not go. Only the government organization have this kind of a public company concept. When we talk about dissemination of knowledge for the common people, then they have. So the public company has a limited area of scope. So you can only form a public company for that purpose. Otherwise, you will have to form a private company. Yes, LLP has a different role and responsibility. It is a shorter or a more centric approach, because you cater to only few people. You only have a limited role and responsibility. But for a company, you go by a lot of legal complications. You have to follow a lot of paperwork, because you have to get your data approved by a lot of statutory authorities. You have to also process it in the company law. Then you have to also see that whether the contract provisions are fulfilled or not. So you have a lot of legal work. So if you want to go for a lot more people, more work, then you go for a company. If you have a limited scope of operation and a limited kind of clientele, then you go for a LLP or a partnership firm. And if you want to run your business on a small scale individually, then you go for a sole proprietorship.
Thank you, Dr. Mansi. Tapanji is asking again, is asking a question. He asks, if anyone is a CEO and director in another company, can he become a director or partner in one more company?
Yes, it depends on the terms and condition. So every company has its terms and conditions. So if I give this right for a partner or for a person to join the other company, he will be able to join. So my roles and responsibilities are clearly mentioned. My benefits are also clearly mentioned. So it depends on the memorandum of understanding. It also depends on memorandum of association of the company, which clearly tells me that whether I can become a member or I cannot become a member. And if I become a member, what will be my stake in this existing company.
A related question is raised by Priyanka Jaiswal also. She says,
Yes, I can become a partner in one more company, but that company law or that company memorandum of association and memorandum of undertaking will tell me whether I can become the partner or not, because this has to be, decided on a mutual basis and as per the terms and condition of my contract.
Uh, Pintu Prasad Gupta has raised a hand, so you may ask your question.
Okay,
Okay.
yes.
Ma'am, previously I was a partner in a partnership firm. So there I applied for a patent, and then I removed from that partnership firm and created my own sole proprietorship firm.
Okay.
So the question was that the patent I have applied was objected. Now, should I continue to make it? I mean to say that should I apply a new patent for my new firm, or uh, should I continue with the old one and then transfer it to the sole proprietorship firm?
Okay, it was rejected on which ground? If it was rejected on the technical ground, that will have a different application. If it is rejected, because, the provisions of the Patent Act are not fulfilled, then it will have different implication. So,
So it was
initially,
objection, not rejected. It was have some objection, and they I have called my CA that there was an objection. So he told me that you have to make a reply, and then further you can proceed. But the question was, on that time I leave that partnership and created my own sole proprietorship.
okay, so what was there in your terms and conditions in that partnership firm? Because as a partner, were you able to have a patent? If you were able to have a patent, and what will be the repercussion? Because if you leave your partnership firm, it should have stated that these are the conditions, that if you leave the partnership firm, the patent which you have, given or you have, developed in being in that partnership, whatever benefits you have, or
Hmm.
whatever expertise you have staying in that partnership, what will be the technological transfer after you shift from that business? So that term and condition will decide whether you can continue as a sole proprietor having that same patent, or whether you will share that benefit with the previous company or your previous firm.
No, I have raised this question with my partner, and he told me that if there is this kind of condition, then I am ready to transfer that patent to your company. But
Actually,
is it eligible? I mean,
yes, if he is ready and it is there in your term and condition is okay. Otherwise, it has to be right in writing, You cannot have a patent from a X company and then you leave that company and you open your own company or a sole proprietor and you claim your patent. So whether you have registered in that patent office as a single patentee or you have registered as a partnership firm, that will, tell you whether you can do it or not, because the partner may not be knowing the legal repercussions now. And
right.
if I tell you that verbally I have spoken to, it's okay. My verbal communication will not have any meaning if the agreement or the clauses have a different connotation. So you discuss your case maybe individually with me. Okay,
Okay,
so
ma'am.
I will be in a better position to guide you.
Okay. Thank you, ma'am.
Thank you.
No, a private limited company cannot be transferred as a public limited company, because both the private limited company and a public limited company have a different sphere of operation. So you have to take all the approvals and you have to say that this company now is a public company. So the registration process is different. The terms and conditions are different when you talk about a public company. And for public company, you have to have government approvals, and only for a limited area of operation we can have a public company.
Tapanjeet Singh has asked for your contact details.
Okay, I have shared my contact details in the PPT also. So I'm just giving you my WhatsApp number. You can just WhatsApp me. Okay. Just send me a WhatsApp message.
I hope all your queries have been answered for now. And since it is time, so we will be concluding this session. And before concluding, I would like to thank our expert for today's session, Dr. Mansi Sharma. Thank you so much. It was
It was my pleasure.
it
Okay.
was a very
Yes, it
informative.
was. It is always a thrilling experience to be here. You know.
Uh, we also enjoyed this session, and I hope the students have benefited a lot. They must be having lot many more questions to ask, and they can contact you also. And the session was very interesting and informative. And on behalf of NCID, I would like to thank you once again for being with us and taking out time for the students. Thank you
Thank
so
you.
much, Dr. Mansi.
Thank you, Dr. Sujata, and thank you, NCID, for giving me this opportunity to interact with the learners. Thank you.
Thank you so much.